Good afternoon, everyone. Allison Skyberg here with Consolidated Planning Group. We're so happy that you have taken time out of your day to join us today for this important topic. If you have attended our webinars in the past, we're glad that you're back. If this is your first time attending, we're certainly glad you're here. Consolidated Planning Group has been putting out webinars for a lot of years now. I am a parent to two adult kids with disabilities, and I was pretty frustrated on how hard everything was when it comes to planning for our loved ones. And so this YouTube channel, we have a Consolidated Planning Group YouTube channel where all of our past webinars live out there, and you can subscribe to that for free and look at past topics. If you can think of it, it's probably out there on that YouTube channel. There's over 500 webinars out there. We talk, and the thing is when we start talking about planning for a loved one with a disability, every topic you could go down a 1 hour rabbit hole, whether you're talking about SSI and Medicaid or Medicare, if you're talking about Medicaid waivers, special needs trust, guardianship. There's so much out there. And we've really tried to label them in such a manner that you can find the information for the step that you're on your planning journey. So we hope that you will find that helpful. We want to empower families. I think so many families, Boyd, feel overwhelmed with all of the things that they're supposed to do or not do, and crossing the T's and dotting the I's, and what you don't do to mess things up. And so that is all out there to help you on your journey, so you feel empowered as opposed to defeated. Because I know, even doing what I do and knowing what I know that I felt like it was a pretty overwhelming process for sure. So today, what we are is we're in a webinar mode, and what that means to you is that we can't see you or hear you, but we do know you're there. A lot of you have taken time to send in questions ahead of today's meeting, so we're going to do things a little bit differently. For our serial attenders, we usually take questions throughout the presentation, which we're going to, but we're going to go over some of the questions that were sent in ahead of time today and go through that. So we invite you to put your questions in the chat box. This webinar is being recorded. It will later be on our YouTube channel, and we also have a podcast that'll go out there too as well. So we aim to get to as many questions as we can during the time that we have together. So we are excited to be partnering back with Boyd Handley in the Handley Law Office. We've done a lot of webinars with him in the past. He is an attorney, and his practice focuses on working with families such as yours that has a loved one with a disability, and he helps people kind of go through and kind of determine what might be the best route from a guardianship perspective or alternatives to guardianship. He helps people with estate planning documents such as wills, trust, special needs trust. Very, very knowledgeable. And what I love about Boyd is Boyd's passion. Boyd, like me, he is a parent to an adult daughter with disabilities as well, and he gets it. And what I really love too, Boyd, is that your passion is also shown in your prices. And we find that Boyd, in working with families, he doesn't break the bank. A lot of times people put off doing some of the things that they need to do because of the affordability of things like that. And so that is something that you can know about Boyd. And that was off the cuff. Sorry, Boyd, but it's the
That's fine.
true story. Just had to tell it. So today what we're going to be talking about is why you should never leave money directly to your child with special needs. And a lot of you know these things, but we're going to talk about what happens when you do. We're going to talk about leaving money to minor children that are not disabled. We're going to talk about some traps with that. And then we're also going to talk about what if it already happened and how to fix stuff like that. So Boyd's going to talk a little bit about those things. Consolidated Planning Group is a holistic special needs financial planning firm. So we're not attorneys. We don't do what Boyd does, and Boyd doesn't do what we do. When you're planning for a loved one with a disability, you need both. You need a planner that is nuanced and special needs, and you need an attorney that is nuanced and special needs. We are an advisory and consulting firm, and people come to us because they want to plan for the future of their loved one. They want to preserve eligibility for state and federally funded programs. They want to make sure that they have money in the right buckets. But quite honestly, when we're planning for a loved one with a disability that may have care needs 25 to 35 years after we're gone, careful planning goes into play because we also want to be comfortable in our own retirement that could last 25 to 35 years as well. So we help people with all of that. We're nationally certified as Social Security advisors, members of the Special Needs Planning Academy. We provide clear direction of how and when to apply for public benefits such as SSI. Sometimes it's SSDI, sometimes it's childhood disability benefits under a parent's record. And we go deep and wide on all of those topics. We help people set up ABLE accounts. We do a lot of transition planning, lifetime care planning, like what's going to happen to your child or where could they live when you're gone or you're no longer able to provide those caregiving services. So if you haven't met with us in the past, we always offer free personalized consultations. And anytime we're doing a presentation like this, questions come up. You may not want to put them in the chat box. Maybe they're private or personal. You can definitely meet with our team and get your questions answered in your free personalized consultations. So when it comes to special needs planning, we believe that the sooner you get started, the better. And I always say it's not about beating yourself up about what you haven't done or what you don't have in place. It's about looking forward and taking intentional steps to get to where you want to be. When we're thinking of like transition and our kids growing up, thinking about a future care plan. We're not always going to be of sound mind or body. We may not physically be able to be the caregiver that we once were. And so thinking about that now while you are healthy and good is a good time to do that. Also starting to consider post-high school educational options, vocational options. Maybe it's working, maybe it's higher education, maybe it's a transition program. Maybe we're going to stay in the public school to age 22 and take advantage of some of the programs there. But we do suggest that you start touring transition programs if they're outside of the public school. Thinking about partial care, full care, residential communities. Some of these waiting lists are long. And so the sooner you get started on that journey, will give you more options in the future. And so one of the things that we also talk about is when it comes to planning, when we see families that haven't planned, what we see is that sometimes the siblings are the future caregiver. And while sometimes this works because maybe a sibling is significantly older than the disabled sibling, a lot of times it doesn't work. It's not a great fit. Your other kids have hopes and dreams that they want to fulfill. Maybe, maybe it's going to college or having a career. Maybe it's getting married. Maybe it's having a house and building their assets, whatever that might be. And so we want the siblings to have a loving, great relationship as opposed to an obligatory relationship that maybe they're not equipped for. So we always like to mention that. So having said that, we're going to get started with some questions, Boyd.
Okay.
And we're going to run through these answers quickly. And if you want to go deeper and wider with us, then you can reach out to Boyd for a free consultation, reach out to us as well. So one question, I'm not going to name any names here. Can a school force a child to wear a pull-up against the parents' wishes?
That's a good question. Normally, what we do with that is be sure you have an advocate and talk with them about it. There's a lot of things that the public schools cannot do, but I think if the young person was having problems in school, it's probably that may be a solution, but definitely should talk to the parents about that.
And as far as educational advocates, we've done a lot of webinars with educational advocates. And what we say, I mean, we're fans of the schools and we love the schools and they work really, really hard and sometimes with both hands behind their back. But what I would say is if you are unhappy with the way things are going and with, your maybe it's your IEP or your 504, maybe you don't have an IEP or a 504 and you should. It is important to reach out to an advocate and understand what your rights are. And a lot of these advocates, I mean, they're designed to work with well with the school. It doesn't have to be an adversarial situation. So check out our YouTube channel. A lot of the stuff where you're gonna have entire topics on the YouTube channel. One person said, can you cover ABLE accounts in some detail? We do have an entire presentation. We've done them in the last 2 weeks, definitely on the YouTube channel. ABLE accounts are under the tax code 529A for ABLE. It's achieving a better life for an individual with a disability. The beauty of the ABLE account is the money in the ABLE account does not count against the individual for SSI or Medicaid purposes. We are all governed by this $2,000 limit, Medicaid limits, whether it's a Medicaid waiver, whether it's SSI, Medicaid. If you want Medicaid, it's the $2,000 limit. You can't have more than $2,000 in the individual's name outside of an ABLE account or a special needs trust. So the ABLE accounts kind of act like a Roth. It's not a Roth IRA, but it's after-tax money that goes in. It can be contributed by anyone. The kid could contribute, grandparents. I could contribute to your kid's ABLE account if I wanted to. And it's subject to the gift tax exclusion. So you can put up to $18,000 a year for 2024. It's going to $19,000 in 2025. Into your kid's ABLE account. If the child is working, you can put an additional $14,580 if they're working up to their earnings amount to that level. Okay, so we'll check out the YouTube channel on that. We help people open up ABLE accounts. You can have any state's ABLE, but if your child is getting SSI and Medicaid, it's a real good idea to have this account. Okay, so we've got one. Boyd, how do I set up a trust for my grandsons?
Definitely get in touch with a lawyer for that. If the grandson is just a minor, then you can have a regular trust for him. If the individual's special needs or disability, then you would definitely need a special needs trust. And be sure that if you do need a special needs trust, that the attorney has done those before. So.
Yeah, Boyd, I echo that so much. This is our situation as parents with kids with disabilities. Our situation is specialized. You want to work with a specialist, not a generalist. Generalist, although they went to law school and they're smart, and I'm not suggesting they're not, they may not be smart in people with disabilities. They may not be educated in public benefits and how to lose those things. And that's really, really important. So I can't stress that enough. Okay, so how do I transition from not having benefits to having SSI? So, and that goes in another one of how to apply for SSI. We help families with that all of the time, so you can reach out to us directly on that. As far as SSI and how much money they can have under their name before losing benefits, it's $2,000. And it's a ridiculously low number, and it hasn't changed in 40 years. And there's some proposed legislation changes to move that to $10,000, but those have been proposed for years and they've never passed. And so if anybody tells you I heard it went to $10,000, you heard wrong. It's not true. There is a higher limit for Medicaid guidelines. I think it's 125,000 in California. There are a few, very, very few states that have changed that. Most states in the U.S. are $2,000. So let's see. So in transitioning from not having benefits to having SSI benefits, there's a lot of things that go into play as with for the person getting SSI, if they're working or not, if they're between the ages of 18 and 22, if there's an earned income exclusion. And it sounds like enough to make your head spin, and it is confusing, but we're educated on all of that, and we'll provide very, very clear guidelines of how and when. And sometimes, we suggest, reaching out first before you apply, because you may have something set up in such a way that's going to be an automatic denial for the SSI. And there's some legitimate moves that you can make to make sure that the money is in the right bucket so you can apply and can get approved. Okay. This is a good question, and there's another question that was similar to this. If I were to pass away, what is the best way to leave my house to my disabled adult child? If in a third-party special needs trust, could his siblings ever live there?
Yeah, they actually can. I normally tell parents if they're going to put a house in a special needs trust, you have to realize that there's some things that the special needs trust cannot pay for. Normally, what I'd like to do is put it into a regular trust, and then the special needs person can live in the house in the regular trust, and then you'd have money in the regular trust to pay for the upkeep on the house. Although I have done a few in a special needs trust, you just have to have money from another area that you can pay for some of the things that the special needs trust can do. And yeah, you can do a transfer on death deed to the trust, or you can actually have a living trust where you can put the house in the trust prior to your death. So transfer on death deed, there's something called a ladybird deed, and both of those two facilities can transfer outside of probate at your death.
One thing I want to make clear is this is where people kind of get confused when we talk about that $2,000 limit, Boyd. In all cases for Medicaid and for SSI, a person could have one house, they could have one car, and
Yep.
it could be in their name and up to $2,000. So you don't have to put a house in a trust. But what I like about the idea of a house being in the trust is it prevents a person with a disability from being hoodooed out of the house or taken advantage of. So that is the true reason. So if there's plenty of people that have a disability that qualify for SSI that don't have an intellectual disability, and maybe they're really sharp with money and there's no chance that that would happen. But for many families, their loved one is in the vulnerable population and could be at risk of being taken advantage of. And so that's what we want to prevent there. One person says, if my daughter has Medicaid, does she have prescription drugs also? So Medicaid comes with prescription drug built into it. Medicare is a different program, and Medicare has four parts: A, B, C, and D. Medicare A is the hospital, Medicare B is the doctors, Medicare C is a supplement plan or an advantage plan, and Part D is prescription drug plans. So when a disabled individual has both Medicare and Medicaid, which we see that a lot, then yes, they would need a prescription drug plan. And it is all very confusing, and we throw those names around: Medicaid, Medicare, it sounds confusing. Medicaid is what comes along with SSI, and Medicare is what your loved one with a disability, if you have a disabled adult child whose disability started prior to age 22 and they're eligible under a parent's record, when the parent turns on their Social Security or Social Security disability, the child will start receiving disabled adult child benefits, might also be called RSDI. For 40 years, they called it DAC, disabled adult child. And after 24 months of receiving those benefits, once they're over 18, and after 24 months of receiving those DAC benefits or CDB benefits, then they will automatically be eligible for Medicare. So I know that's a mouthful, but that's about how it works. Okay. One person, and we're going to address this in just a moment, is it okay to have our son with a disability as a beneficiary on our life insurance? And no, we never want to do that, but we're going to tell you the right way to do that today. Is there an importance that I have to be her legal guardian? I am her legal paternal mother. And so the guardianship, you're automatically the guardian until they turn 18. And so whether or not an 18 plus person needs guardianship or partial guardianship, people like Boyd and attorneys that work in special needs, they're designed to talk with you, to talk with your child. And in Texas, it's the least restrictive and most appropriate. Is that right,
That's
Boyd?
correct.
And that's true for a lot of states. Some states have different rules, but they want whatever the least restricted options are that is most appropriate for the individual. So there's full guardianship, partial guardianship, and then there's alternatives to guardianship. And I know we've done complete webinars with Boyd on this, on supported decision making agreement, guardianship, full guardianship, partial guardianship, and the steps that you have to go through. But you cannot get guardianship prior to them turning 18 because you're already their guardian, basically. So you don't need to do anything early. And you do suggest starting that process, what, 3 to 6 months in advance? Is that right?
Yeah, we can, in Texas, we can file 6 months prior to the 18th birthday. And I tell parents to give me a call at 8 months where we can start getting the paperwork from the doctors and stuff. I do more partial guardianships than full. You can actually have where the individual, I've got some clients that kids are driving, which I'm a little hesitant about. And then, of course, you can vote and a few other things. So, parents just have to realize that They may not need a full, and guardianship is not permanent. They can always go back to court and give some rights back to the individuals.
Okay, this is a great one. My daughter has already received an inheritance from her great grandfather. It's set to receive when she turns 21. And this is what I call an oops first party special needs trust. So there is a fix for this. You can't undo, and you can't just say, I'm not going to take the money or disinherit the money, because those are all ideas people have had. But you can set up a first party special needs trust, and then you just have to go to the courts and have that redirected to a first party special needs trust, Boyd.
Yeah, if you can get the trustee to do an amendment to the trust fund saying it does go to the special needs trust, or if they won't do that, then we would have to go to court and have it ordered to go to the first party trust. Yes.
But there is a fix for this, and you do want to get this fixed prior to applying for SSI, because it will affect, those assets will affect SSI. And you do want to try to get this fixed before they turn 21 if you can. I mean, you can go back and get it fixed retroactive, so don't panic.
Yeah.
But
Uh,
the sooner the better on that one.
yeah. If your child has not turned 18 yet, then I would probably suggest getting an amendment to the trust going to a third party trust. We'll talk about that, because what you don't want to do is have a lot of money go to a first party trust, which is has Medicaid payback. So we're not going into that on this presentation, but there's a few things that you can do if your child has not turned 18 on that trust fund.
So that might be a one-off with you or an attorney nuanced in that. Great. These are great questions, and thank you everyone for sending them in. My ex-wife got guardianship, and it makes it difficult for me to spend good quality time with my son. That I would say, so here's the thing. When there's a divorce involved, and so you got your attorney like Boyd that handles estate planning things and guardianship and special needs trust, and then we have a whole list of divorce attorneys and child support attorneys that are nuanced and special needs that may be able to help, and that may be where you need to go with that. I'm sorry that that's happening to you, but it's not going to be the Handley Law Office that would handle those types of matters of custody and visitation and things like that. But having a divorce attorney that is nuanced and special needs is a good place to think about that. So is there a name of person that could help me in Chicago? So from our perspective, Consolidated Planning Group, we work all across the United States, not just in Texas, so we can definitely help you there. When it comes to selecting an attorney in another state, the two places that I recommend people look is the National Association of Elder Law Attorneys, also known as NALA, National Association of Elder Law Attorneys. You can put in your zip code and you can find attorneys in your area. Of course, we have recommendations for all over our state of attorneys that are nuanced and special needs, but National Association of Elder Law Attorneys, as well as the Special Needs Planning Academy. You can Google the Special Needs Planning Academy and you can put in your zip code, and up will come attorneys that are nuanced and special needs in your area. So then we just have a few more, and we're going to go right in, and don't worry guys, we're going to be right on time today, so no worries on this. The difference between an ABLE account and special needs trust. So again, lots of webinars on our YouTube channel on this, but the bottom line is the ABLE account you can put a limited amount of money into an ABLE account. As I mentioned, $18,000 a year, subject to the gift tax exclusion. You cannot have more than $100,000 in your ABLE account prior to disqualifying for SSI and Medicaid. So if you Google how much money could I have in an ABLE account, it might tell you $500,000 or $550,000. It might be $600,000 now. And that's true as long as you don't care about Medicaid and SSI, which most of the families we serve do. So your number is 100,000. One penny over 100,000, you lose Medicaid and SSI. An ABLE account can pay, if it can be construed as achieving a better life for an individual with a disability, you can pay for it out of an ABLE account. You can pay for shelter, monthly debt service, rent, utilities, professional services, transition programs, medical services, most anything. You could actually even pay for a vacation for the individual with 1 to 2 caregivers out of an ABLE account. But it's a limited amount of money that you can put in each year and a limited amount of money that you can have before you disqualify for SSI and Medicaid. In a special needs trust, you could have an unlimited amount of money in a special needs trust, and you could put an unlimited amount of money into a special needs trust each year. You can leave life insurance proceeds like the beneficiary as a special needs trust. You cannot leave an ABLE account as a beneficiary. That it doesn't work that way. And basically, a special needs trust is really designed to supplement or supplant the needs, right, Boyd, of the individual with a disability. But there are some limitations, and there is a 1/3 reduction to SSI if you pay for shelter out of a special needs trust. So some people, I've heard this many times, of you can't pay for shelter out of a special needs trust, and that's not true. You can, but there would be a 1/3 reduction to SSI as the rules are right now. Is that right?
Yeah, that's correct. Normally, a lot of parents have their kids in group homes or say in Houston, Brookwood, and it's a large amount of money each month. And we used to have a very good friend who was in SSI who's retired now, but he basically told me that, you know, in an able account, you can put so much money. If you're paying 5,000 a month, say for Brookwood, then that money's going to go out real quickly, and you'll never be able to reimburse it. So what we tell parents is just go ahead and pay for group homes and Brookwood or some similar to that out of your own pocket, and then use your special needs trust to pay for the other things. Normally, what we do with the special needs trust and able account is work together because, as Allison, as you mentioned, you can pay for almost anything from the able account, including cash, to the beneficiary, and you can move money from your special needs trust to the able account. So, but then
And
again,
it,
they work together.
And in line with that, we had somebody in the chat box that said that they opened a 529C for college before they knew that their child had cognitive issues. Can you transfer money from a regular 529 to an ABLE account? And the answer is yes, and it's $18,000 a year, and next year it'd be 19,000. So, and the cool thing about that is you can pay for higher education should the child go to higher education out of an ABLE account, but you can't use the funds in a 529C for all of the things that you could use them for. A 529A is much less restrictive than a 529C. So yes, and we can definitely help you on that. Okay, we are grandparents who reside in Arkansas. However, our grandchildren reside in Texas. And so I think what they're asking, there's not really a question, but I think what they're asking is, they can set up a special needs trust could truly be set up in any state, the state that the grandparents reside in, for the benefit of said child that lives in any state. Is that correct?
Yeah, that's correct. You can have as many third-party special needs trusts as you want. You can only have one first-party trust, and a third party is like a third party. Third parties can give to the trust. We do a lot of that in divorce situations where one side of the family has one special needs trust and the other has another one. So the grandparents can set up a special needs trust themselves and for their grandkids, or have a contingent trust in their will for their grandkids. Yes.
Got it. Okay. And so as Boyd mentioned, and again, entire webinars on this topic, so you can go deep and wide on first party and third party special needs trust, how they work, what are the differences of those. That's all on the YouTube channel. What do you do if you cannot afford to pay an attorney to set up a special needs trust, but the child gets SSI and child support? So I think of legal, if you go to our friend, I call it our friend Google, and you type in legal aid services for your county, a list of the legal aid, there's Disability Rights Texas, other states have disability rights organizations. There are legal aid groups that will pop up on your Google search. And if you are a family that is considered indigent by their standards, whatever their standards may be, they may have sliding scale pay where it's a lot cheaper, or it may be free. So there are options out there. And I always like to mention that there is free guardianship in Galveston County. If you live in Galveston County, they have a grant. And so there is a such thing as free guardianship in Galveston County. And then there's another area in and around San Antonio. It's not Bexar County, but there's like this small little area up there. Those are the only two places that I know in the state that have it um, through the county, through that program.
Well, I will say in Fort Bend County, there's this Brazos Bend Guardianship Services, and they actually give grants out to individuals that qualify, and basically they have another attorneys that they pay with the grant, and then you can apply for not able to pay for it when you file the application, and all the fees are free in the county. And Harris County has some similar things. So,
The bottom line is there's help, and I don't care where you're at. If you're in Chicago, if you're in Arkansas, or whatever, there are help for indigent families or people with modest means out there. So you do want to check into that. Okay, so this is there a minimum amount of money to open a trust?
we normally put $5 or $10 down in it, and basically, a lot of times with these trusts, they're not funded until you pass away. In my situation, we've got a trust. It's not funded yet, although I guess it is actually. I haven't funded it. My parents funded a little bit, but mine will be funded if my wife and I die in an accident. And so, normally, if we get a tax ID number, we put a ceremonial $5 bill to the trust, and it's funded for tax purposes. So
I love that. So you don't have to be a millionaire to do this. That's awesome. And then so when it comes, and I will say when it comes to funding a trust, I'm a huge fan of using life insurance to fund a trust. Now, clearly, you could be a millionaire and you have plenty of money to fund the trust, plenty of assets. But what I like to do, I like to keep in mind that a family may have 25 to 35 years that they're going to spend in retirement. And I like to keep their assets nimble for them during their retirement and to know that everything's fine. And that if there's money left over after 25 to 35 years of retirement, then great, that can go to the trust. But we have life insurance as an umbrella of just in case of that can go to the trust. Life insurance also passes tax free to heirs, and a lot of people use this as another bucket, like a kind of an asset bucket and a tax favorable bucket. This is a great question. I actually talked to this guy this week. When my wife and I die, my daughter will get 75% of my Social Security, which is true. This is survivor benefits. And again, other webinars on this topic. So when we have a disabled adult child under a parent's record whose disability started prior to age 22, if the parent dies, they'll get 75% of the parent's record. While the parent's alive, it's 50%. It moves up to 75%. This will bring her way over the limit to keep benefits. I'm concerned about this, that when I die, then she's going to lose her Medicaid waiver, she's going to lose Medicaid, and that is exempt. That increase of that 50 to 25, and I was able to send an email with the chapter and verse in the Medicaid handbook of where that would be exempt and an exclusion and not counted. So if you're sitting out here and you've wondered that before, that if I die and the childhood disability benefits or survivor benefits go to 75%, then the wheels are going to come completely off the bus. It is not true, and you will be able to maintain those benefits. So that I love that question. Okay, couple more, and then again, we're still good on time. We're still great. We talked about the 529. Can a house be put in the trust specifically as a rental property where it's professionally managed and the rental income goes to the trust?
I would probably not do that. The house should probably be in an LLC. You can put an LLC in a trust, but I wouldn't put it in a special needs trust uh, at all. So I wouldn't mess. You can put it in a trust, and then the income can come back to the trust, but there's too many restrictions in a special needs trust for trying to do that.
So a regular trust would work out, and what we see a lot of families do, Boyd, is that that maybe upon the death of the person that the house is sold and the proceeds go to the special needs trust as opposed to dealing with rental properties. And one tip that we give families that have rental properties, get out of them before you're too old. So it's not saying it's a bad idea, but what I am saying is when you're 80 or 85, you're not as spry as you used to. And we've seen people get taken advantage of that had like lots of rental properties, maybe, or mobile home parks or other things like that. So get out of it when you're still spry and you can, not, we don't want anybody to get hurt or get taken advantage of. Okay, one person says, I have a special needs trust for my daughter and a regular trust. Should I put the mortgage for my house in the special needs trust or any other property I also own in the trust?
Again, it's a lot easier to keep them in a regular trust, and then you can, because once you put into a uh, first party trust or a third party trust, I guess, there's so many restrictions, and it's more of a headache than not. Uh, and I have a lot of clients that have put that into a regular trust, and then they fund the third party trust from that as they go forward. So.
This is a good one, and this one comes up a lot. So, we were talking about guardianship earlier and the law of the least restrictive and most appropriate. This question says, I have an adult senior aunt with intellectual disabilities in her 60s. My grandparents passed away back in 2006. Guardianship was never done after they passed. Should her adult siblings at least have a minimum like power of attorney or medical power of attorney? And this is a slippery slope, Boyd, and I know you and I have talked about this before about
Yep.
capacity to understand what an individual is signing. So if a person has an intellectual disability and they do not have the capacity to enter into a contract to truly understand what they're signing, can you do a power of attorney or medical power of attorney? And if you do, what are some consequences that could come from that?
Well, according to law, you have to have the capacity to understand the legal and personal ramifications of power of attorney and medical power of attorney. So, in my practice, if you've got a 70 IQ or below, I won't even do one. I know that there's a couple of firms that will do down to 65 total IQ score. So, if you're below 65, no one's going to do a power of attorney and medical power of attorney for you. So, if you do one for an individual that doesn't have the capacity, then a third party could come back on you and say that you're trying to swindle or you've committed fraud because the individuals did not understand what they were signing. So, uh, and then I've had a number of clients that we were going through starting guardianship, and they have shown me a physician certificate saying that their young person didn't have capacity. And then they say, well, we've decided not to do a guardianship, but we're going to do a power of attorney. I say, well, I'm sorry, I can't do that because I've
Right.
already seen the physician certificate that said they're incapacitated. So it's as you mentioned, it's a slippery slope, and you have to be very careful when having these individuals do it. I have done two or three in my practice, but I've had the young person, well, they were 18 in one conference room and the parents in another. And I would actually quiz the individual to see if they understood without looking to the left or right for mom and dad to say yes or no. So I don't like doing those because it is a very questionable whether these individuals understand what they're signing.
Okay, last question, and then we're gonna just dive right into the topic. What these are all really, really great questions, and I love that you guys send them in, and I think it's helpful for everybody out here. The last question that we're going to talk about right now is if some money from the beneficiary made it into the third party special needs trust, i.e., from a $1,000 life insurance paid to the beneficiary, does this ruin the third party status?
Yeah, what we've done with my family is, of course, I've got uh, everything going to my wife first, and then between my retirement funds and my life insurance, it names my daughter's third-party trust as successor beneficiary. So that happens all the time.
Okay, so I think what they're asking though is if it already happened. So if $1,000 accidentally went into this third party special needs trust from life insurance. Well, if it was life insurance proceeds paid to the individual, so basically it wasn't paid to the trust, it was paid to the individual, but it was only $1,000. Is that a deal breaker?
Not as long as the account that it's in is not over $2,000 at the first day of the month. And SSI, is going to run your social every once in a while, and that's how they find out that the accounts are over $2,000. If it's over $2,000, you're just end up losing SSI and Medicaid for a short period of time, and then possibly having to pay back what was paid during that period. So,
Bottom line is it's not the end of the world and it can
yeah,
be worked out. Okay,
that's correct. Yeah.
awesome. All right, I know you, I'm gonna mute my video and audio. Thanks everybody for your awesome questions. We're gonna let Boyd take it away. He always has to go through his disclaimer. You can continue to put your questions in the chat box and I'll monitor them. I'll pop back in if we have some additional questions, okay?
Sounds good. Glad everybody can be here today. Looks like we've got a quite a good group, and I'm always proud to help Allison out with this and appreciate her letting me in. All the information today is just general information. Everyone's personal situation is different, so just treat this as such. Next slide. We do a lot of other services. As Allison said, my wife and I have a daughter with special needs. She's 30. We've had guardianship of her since she was 18, so we've gone through this as a parent also. Uh, in Texas, yeah, thank you. Skip one, go back one slide. Yep. In Texas, what we're going to talk about is what if you have a minor in Texas, which is in reality is someone under the age of 18, or if you have a loved one that's over 18 that you have guardianship of, and can those individuals inherit property within Texas? Next slide. In Texas, yes, a minor can inherit property or a person under guardianship can inherit property, but there's really nothing they can do about it until that child turns 18 and they become an adult, or you go into guardianship and then the parent would have to do guardianship of the estate for the guardian to look after the property that that individual has held. There are different ways to fix this. Most of the issues that I represent are families that have died without a will and the minors that inherited property, excuse me, or someone named them in a will by name, and we have to fix that. Next slide. What we're going to do, one of the reasons, as you probably all know, and we've talked about it already, is that if you're receiving SSI and Medicaid, you cannot have over $2,000 in assets, although you can later on have a house or a car. But if someone does receive an inheritance without it getting properly fixed in probate court, then they can lose their government benefits. We actually had a situation with my daughter about 2 months after she started her SSI and Medicaid. When she turned 18, all of a sudden they cut off everything. We had forgotten that my parents had given her some savings bonds back when she was very young, and had them sitting in our safe in a closet and forgot about them. And a few of those had her social security number attached to it. So when, as I mentioned, when Social Security runs the numbers, or SSI runs the your socials, and they came up with that number. So we actually had to sell off the bonds, which were not quite done yet, and then tell SSI that we were back below the $2,000 limit. And as my wife can contest, it took a number of months to get everything back going because SSI and Medicaid do not talk to each other. Next slide. Here are a couple of examples. I hate going through slides, but I always like to give examples of what happens if a loved one under SSI or Medicaid or means dependent government benefits receives money or an inheritance, or what happens if your loved one under the age of 18 receives something. Uh, a lot of parents say, okay, well, what we're going to do is we're going to give the end of our uh, neurotypical child all the inheritance, and he's going to look after his brother or sister. This was an actual case that I had where uh, the parents had a neurotypical child and the daughter with special needs, and they decided to give all the inheritance. Uh, and we actually had to change their will to fix this to the uh, uh, sibling. And in this particular situation, I'm sure where it went all the way through, the parents had died. But in my particular situation, we did change the will. And they were going to give everything to their typical child, and then he was unfortunately in an auto accident where a individual was killed, and it was his fault. So he in this situation he would have lost all the inheritance. So what we actually did in this case was it actually happened to the older sibling, and we ended up changing everything prior to the parents dying. So just be aware that if you're thinking about something like this, there's weird stuff that can really come up that can put a damper on it. Next slide.
I just also want to say that people get divorced, people get sick. There's a lot of things that could happen, and the other person, so disinheriting and leaving it to the other person, then the proceeds could get tied up in a divorce. It's ugly, and people die. So
Yep.
if the other person died and it wasn't set up properly, it could go to the estate of that person and never to the special needs individual. So I view this as a train wreck, and it's a terrible idea. I see people doing it that don't want to spend the money to get the special needs trust set up like as a like circumnavigate or whatever. I just really trust my sister. I really trust my dad, and I get all of those things and I feel the same way, but it doesn't take away the fact of divorce, death, illness, other major things that could happen. The truth is, and if you look around, look at your own life and look at everybody you know, the truth is that life happens, and sometimes it isn't pretty.
And the thing about this is that you can set up a special needs trust now and fix your wills, and it's a lot cheaper now than having to go through it and do it in the probate court because it gets real expensive and it's just a nightmare. Uh, these two are two examples that I've actually had in my practice. A father died and left his 7-year-old son a $250,000 life insurance policy, and then I had a father die also, and I had a large retirement account with no beneficiaries named. Uh, and this was without a will. And so his two minor kids got 50% each. What happens with this, with the life insurance company or the retirement fund, is that the financial institution is going to tell the surviving parent who's trying to get through a funeral and everything else and mourn and look after his or her kids. Uh, there's only three ways you can get to the money. You can wait until the minor turns 18, and we sure do not want a 18-year-old getting $250,000 life insurance policy at age 18. Or you can have the funds deposited into a UTMA account, Uniform Transfers to Minor account, and then they can get the money at 21, which is just about as bad as 18. Or you can have the surviving parent attain guardianship of the estate of their own child. I did this twice with example A and example B. In example B, we have two minors, so we're having to do a separate guardianship of the estate for each of the minor kids. And guardianship of the state in Texas is a major operation. You have to, the parent, in this situation, the parent had to post a $250,000 bond to look after as the guardian of the estate of her 7-year-old son. And then, in order to get the money from all of this, you have to get court approval each time. So it's a process where all you would have to do in this would have a contingent trust in your will, naming the life insurance policy going to that. And then again, don't die without a will, because that's the worst things that you can do. Even if you don't have a lot of money, you need to have beneficiaries named on those accounts.
I just want to add two things to everything that you said there. For anybody that's on here that has a military pension, a VA pension, a military pension, pensions through TRS or any of the ERS, any of the pensions, if you want the pension, like the military and the VA, they have pensions that can go to, they call it a helpless child is what they call it in the military, as opposed to a disabled adult child like the Social Security Administration. The law changed in 2015, and you can have that pension for this special needs child go directly to a first party special needs trust as opposed to the individual directly. So it used to be that you couldn't, and it was messing these kids up and making them lose benefits. But the law changed in 2015. It's the Howard P. Buck McKeon National Defense Act of 2015 that changed that law. So those military pensions can be redirected to a first party special needs trust. So you're going to need to work with somebody on that. That's really, really important. It's really important. You think you're helping your kid by leaving your pension and say it's $2,000 a month. But if it's not, that pension is not going to a first party special needs trust, you might be hurting that kid. So you really need to work with a professional on this. It is really, really important on those little pensions. Sadly, pensions are kind of a thing of the past. There's not very many pensions swirling around out there other than the military and the VA. And then we definitely see the teachers' retirement system, some of the doctors in Texas for sure. But pensions are few and far between. But this is something that slips through the cracks commonly, and it gets missed.
Yeah, I will mention I don't handle VA stuff, but I have done a couple of special needs trusts where we had a teacher's retirement fund and then the City of Houston retirement fund. And definitely, if you've got something like that, going to a trust, whether it's a trust or special needs trust, when the beneficiary of the trust dies, you have to have some of these institutions require specific language on how to distribute the funds after that particular beneficiary dies. And I've had to change the language based on teachers' retirement requirements and the City of Houston. So just be aware of that.
We do. So a person said, can a grandparent leave a military pension and VA pension to be left to a grandchild? You'll have to check directly with them. I think you can change your beneficiary. There is a helpless child for the parent, so you'll want to look into that a little bit further. But I do have two specific attorneys in Texas, one in Dallas, one in San Antonio, that is specifically nuanced and working with the military pensions and some of the VA pensions. So I can make a referral on that. Does a special needs trust need to say it is a special needs trust? What are the minimum requirements for the Social Security office to consider it a special needs trust? And I've read recently, Boyd, that it doesn't necessarily have to say it's a special needs trust as long as it's set up properly and the wording inside of the trust meets their guidelines. Is that right?
Yeah, that's correct. You can have the John Doe Supplemental Needs Trust or something. I always like to put whether it's a third party or first party, it makes a big difference. And there are some parents that do not want that in the title of their trust for whatever reason, but I always like to put that in just so Social Security knows what you're trying to do with that. But it's really language within the body of the trust that uh, does that with that. Yeah. And I will
Boyd, we
say,
have about 7 minutes left for today, so tell me if you want me to move forward on
yeah,
our work.
let's keep going. Let me go through this one example. Go back one. Um, is We had another real life situation. We had a father that died during the COVID and left his 40-year-old son that receives SSI and Medicaid by name uh, his uh, inheritance. And what we were able to do with this particular one, we went to a probate court. We actually approved a reformation of the will, which said in the will that instead of giving this gentleman an inheritance, that it would go to a third party special needs trust, and that's a 1301 trust within the court system. Uh, if this particular individual had been a minor, then we would have requested that his inheritance goes to a 1301 management trust. So there are ways to fix things within the probate court if you do run, in a situation like this. Next slide.
But in summary, Boyd, and because I just want to repeat back, we've talked about a lot, and if you don't do this, it feels like a lot.
Mhm.
But in summary, the bottom line is we should not name our minor children, whether they have disabilities or not, directly as a beneficiary. That's a bad idea. The smart way to do it is to leave it in trust. Not name a minor beneficiary or leave it in a specific trust set up the way you want it to be set up, as opposed to the money being sit on until they turn 18. We don't name minor beneficiaries. We never, whether they're minors or adults, name our, if your kid's name is John Doe, we're never naming John Doe on anything we have. Not bank accounts, not life insurance, not investment accounts. That's the wrong way to do it. The way to do it is to leave it to a third party special needs trust for the benefit of John Doe, and then it preserves John's benefits. So that's the biggest takeaway, and I just wanted to do a recap on that. Anything you want to add to that?
No, that's true. You either put it for minors, what we normally do is have a contingent trust in the will, which is the testamentary, which stays dormant until you die. And for minors, we normally say that between birth and age 18, you pay for what normally you pay for. 18 to 25, you pay for college, a car, an apartment. They may want to get half at age 25 and then half at age 30. And that's for typical kids. For your kids with disabilities or special needs, for sure, goes to the third party special needs trust, which can be a testamentary trust in your will that stays dormant until you die. But we have a name of it in your will, so you can still go to your retirement funds or your life insurance and put that name as the successor beneficiary. So
So the bottom line is you can have a testamentary special needs trust. It's dormant. It becomes activated upon your death. So if you are the one that you know it's only going to be you funding the trust for your kid, then that's a fine way to get things going, especially if you're on a budget. However, I want to mention a problem that we have seen is where grandparents or aunts or uncles or somebody else dies and wants to leave money to the said kid. Your testamentary special needs trust does not activate on mom or dad or grandma or grandpa's death. So if grandma, grandpa, or other family members plan to leave money to your special needs child, then you do need to have a standalone trust. And a
that's correct.
testamentary trust is not going to cut it. I just like to mention that because I think sometimes people forget about that. And sometimes grandma and grandpa keep their cards close to their chest, and they don't necessarily tell mom and dad that they were planning on leaving money to little Johnny. Grandma and grandpa's advisor is not nuanced in special needs, and so when they say I have a grandson who has special needs and we want to leave our money to him, they say great, what's his name? And that is how it accidentally gets messed up, and then you got to have an attorney to unwind that. So I just wanted to mention that as well. So if you've got people that you know are leaving an inheritance to your child, then you need a standalone special needs.
Yeah, that's correct. And normally the way we do that is have a standalone trust. And then if you do know of family members that will be giving money to your child, they can do a codicil to their will, naming that outside special needs trust as the beneficiary. So, uh,
So, Boyd, I know that we're kind of out of time, and I know
yep,
we've
that's
done
fine.
wills and trust and guardianship, and that's all on our YouTube channel. Inquiring minds want to know, and since I'm the finance side, give us a range of like what does it cost to get a special needs trust or a will package with the special needs trust set up? Just a range is fine. Give us a range of a non-contested guardianship and what a person could be looking at. I mean, obviously, Boyd can't speak for other attorneys. He can give you a range for his firm, but tell us a little bit about that.
Yeah, as for guardianships, you're probably looking at with all the fees involved, about 3,700 for minimum, and they can go up to 10,000 depending on the size of the law firm. And that 3,800 or so is the filing fees, the attorney that files it fees. You've got the attorney ad litem fees and the bond and all everything else. Will packages can start out around 1,500 and go up to 3,000 in general. And then a special needs trust, they can run between 13 and 2,500 depending on what's in it. If you get into a living trust, they're going to be quite a bit more money. So
Okay, so we've got Boyd Handley's law office, and you can see this beautiful picture of his wife Carrie and his daughter Caitlin. We love them so much. So check Boyd out. You can certainly schedule your free personalized consultation with Boyd, and he can kind of talk to you further and take a deeper dive with you on your situation, what you already have in place, what knobs might need to be turned for things to be set up properly. Now, I want to mention, I guess you guys saw that I kind of forwarded through a lot of slides on special needs trust and guardianship and some of these other things. The good news is everybody's getting a copy of today's slides and a link to the recording. It'll have Boyd's contact information, Consolidated Planning Group's contact information, so you guys can reach out to us directly. So you're not going to miss any of the information. We're just out of time. We always want to be conscious of everybody's time. In the slides, you'll have this link for our upcoming webinars. It'll tell you the other webinars that we have coming up over the next month or so that you can register for. We work on a collaborative team here at CPG. You've seen Michelle a lot. She does a lot of webinars with us as well, and myself. Again, nationally certified as Social Security advisors, members of the Special Needs Planning Academy. So if you have questions today, you needed to take a deeper dive on things that we didn't get to, certainly reach out. We can definitely help you. And I always just want to remind you, it's not too late. You're not too late. You might feel behind and you might be beating yourself up about that. Or, the person that said, they died in 2006 and this person has an intellectual disability and is not under guardianship. It's not too late. You guys can still pick up where you are right now and get things in place that would be appropriate. Maybe you don't have a special needs trust. It's not too late. Maybe you have a will, or you've never had a will, or you have a will that's 15 years old. We really recommend that you work with an attorney every 3 to 5 years to look at your will and your special needs trust. Laws change, things change, people change. What was good for you 15 years ago is probably not good for you now. And the funny thing is, Boyd, I looked at it and looked at what I had done years ago and then updated it, and we were laughing at some of the things that we had in our documents because it was appropriate then. It was so not appropriate at that time. So anyway, guys, thanks for today. Thank you guys for asking wonderful questions. You really truly helped everybody. This is our QR code. If you want to schedule a free personalized consultation with Consolidated Planning Group, it'll take you to a calendar and you can schedule a time that is convenient for you. Thanks again, Boyd, for being here with us today. This
absolutely.
was
Thank you.
an awesome presentation, and I am grateful that we had the opportunity to work together again. So thanks so much, everyone. Have
Take
a
care.
great afternoon, and we'll catch up soon.